The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Hello, we are here today in our case number CV19-0056, Woods v. Mccarty. Counsel, if you'll please identify yourself before you speak. You each have 20 minutes. Let's go.
Your Honor, Kevin Wright, on behalf of the appellant petitioner / cross appellee Michelle Mccarty Woods, I'd like to initially reserve 5 minutes of my time for rebuttal.
You'll keep track of that yourself.
Will do, Your Honor. Your Honor, the reason why we're here today, as much as I'm honored to be here for the first time arguing in front of the appellate court here in Arizona, is unfortunate. I think it's abundantly clear that the reason we're here today is because we have a fiduciary who is only interested in her own benefit. The trustee, Jane Mccarty, who is the respondent in this case, owes fiduciary duties with respect to this trust agreement both to herself and also to the remainder beneficiaries. Unfortunately, over the past several years, it's become abundantly clear that she has no interest in actually satisfying those fiduciary obligations. The trust is a unique one. The trust was created by the settlor Roger Mccarty. Prior to his death, he amended it several times, ultimately restated the trust, and that is the governing instrument here today. Ms. Mccarty is the surviving spouse. Mccarty, as in Jane Mccarty, not Mccarty Woods. Jane Mccarty is the surviving spouse. She's also the sole trustee of the trust. Upon Mr. McCarty's death, 3 trusts were apparently created, 3 what we refer to as the marital trusts in the brief. The marital trusts are specific. They are governed largely by federal statute, specifically because they are what are called qualified terminable interest property trusts. The reason why that's relevant here is a qualified terminable interest property trust specifically requires certain provisions in the disposition of the assets. 1, the surviving spouse must receive all income, at least annually. That is an absolute requirement for it to qualify. 2, and more importantly here in this case, the principal assets are restricted in some way. So in this situation, the settlor, when he created the trust agreement, specifically put contours around when the trustee could make distributions to Ms. Mccarty as the beneficiary, encroaching principal from the trust. Those restrictions are provided in our brief, but they are not unfettered, and that's a key point here. If they were unfettered, I don't think we'd be here today. Instead, we'd be dealing with a situation which you may have referred to or heard previously as a survivor's trust, in which the surviving spouse has complete and total control and access to. Here, instead, we have a trust that specifically restricts the encroachment of principal, and the reason for that is the principal is supposed to be held.
Counsel,
Yes.
I'd like to jump ahead
Sure.
a little bit. And so I apologize, we may end up jumping around, but one of the first things I wanted to get at was this interested person argument.
Sure.
And no offense to anybody, I'm going to use first names just because it's easier.
It's probably easier, Your Honor.
Michelle is your client is contending that she is at the very minimum an interested person.
That's correct, Your Honor.
Can you talk to me about what, if any, limiting principle there is to who is an interested person in this universe, and talk to me about the distinction between an interested person and a beneficiary? At what point is there a limit to who is an interested person?
Sure, Your Honor. I think that's an excellent question. And actually, in Texas, which I understand both of you previously practiced in, Texas has had some cases where they've determined an individual is not an interested person, but it is limited. So, for example, there is a case that specifically deals with, and it's cited in our briefs, that specifically deals with an individual who was the father of beneficiaries who were recipients of an educational trust. The father was not to receive any assets unless a couple of things happened. 1, his children died, and 2, his children would have needed to have died intestate, so without a will of any kind. That is what's referred to as a contingent beneficiary. And in that case, the court determined that he did not have standing. He was not an interested person with respect to the children's trust because his interest was so remote. In this case, and I think why Michelle is so clearly an interested person, is that unlike that case I just referenced, as I was getting into a moment ago, the principle that is held in these marital trusts is ultimately being held for both the benefit of the current beneficiary, which is Jane, but also for the remainder beneficiaries. The remainder beneficiaries hold a possessory interest in the principle in the marital trusts. It is there to exist and held for their ultimate benefit. So with respect to Michelle standing as a beneficiary, she clearly stands in that capacity because she has a remainder interest that is what's called vested, meaning it can't change. Jane can't change that interest. She can't.
Can you be, counsel,
Sure.
can you be not a beneficiary but still an interested person?
Absolutely, and the statute in Texas specifically contemplates that.
Give me an example of who falls into that category.
Sure, a trustee could be potentially an interested person.
Okay. Who else? A trustee?
A third party who would have a direct influence on their ability to access funds in the future. A guardian ad litem on behalf of a beneficiary could act in that capacity. A bank who might have a third-party interest in the disposition of the assets.
So instead of looking sort of myopically at the words, the definition, is there either common law or a statute that provides color to the word interested, an interested party, such that we could glean what this is trying to, what universe of people this is trying to capture?
Sure. Well, the Texas statute that we cite in our brief is the definition statute of that. So that specific statute, it's actually very analogous to
Vested,
the one
unvested, future, right.
Correct.
What I'm saying is, beyond that, is there something that explains why we are identifying these two groups, beneficiaries and interested persons, as the universe of prospective petitioners in this form of case?
Is there a specific case you're requesting, or another statute, or?
Right. I don't, a case or a statute. Obviously, we have the definition, but I mean, I guess I'm looking for some direction on maybe, I don't know if it's obvious or not, but you know why we have those two categories and what the words interested person, who that's intended to cover, the policy rationale, driving that.
Sure, Your Honor. I think I can address that. And maybe it is because I'm embroiled in this as a practitioner. It is obvious to me because Arizona has an analogous statute. It's in 14-1201. An interested person, by definition, must include a broader category than simply a beneficiary. Beneficiary is contained in the definition. So the intention of the policy behind the term interested person is that the legislature, clearly here in Arizona, clearly in Texas, identified that persons beyond the term beneficiary might have an interest in the disposition and administration of a trust. So for the examples I gave you, a guardian ad litem on behalf of a child beneficiary, a guardian, for example, a third-party bank who might have an interest in the disposition, might file an interlocutory appeal on that basis. There's all kinds of those things. And the specific statute that's cited in Texas, also analogous to Arizona, enumerates examples, but they're not exhaustive because the second sentence there, I won't quote it verbatim, but essentially says it's a facts and circumstances analysis. The status of an interested person is based on the facts and circumstances and the relationship to the request sought. So it's hard for me to give you a bright line test about where the line is drawn for an interested person because I don't think that's what the legislature in Texas or frankly in Arizona intended. They intended with respect to interested person analysis for it to be on a case-by-case basis. Now our argument...
You don't concede, I don't think, at least reading your briefs, that you aren't a beneficiary or your client is not a beneficiary.
We do not, Your Honor.
Okay.
We think she is a vested remainder beneficiary.
Assume, just for purposes of this argument, that I disagree with you, that she's not a vested remainder beneficiary because the trust that she's a beneficiary of has not been created.
Mm-hmm.
Your fallback argument then is that she's an interested person.
Fallback isn't perhaps the way I would put it, but yes, the interested person necessarily encapsulates the beneficiary argument.
Can you respond to your opponent's argument that you guys did not sufficiently develop that argument below, and that we should therefore treat it as waived?
Well, I think we covered this in depth in our brief, and I think we did. I mean, obviously, Arizona's a notice.
One footnote.
Well, I think it is more
And then
than
in a reply. I mean, you need to, usually we require a little bit more. Wouldn't you agree with that?
I would disagree in this respect, Your Honor, because specifically the position we took is that the interested person analysis necessarily is covered by the beneficiary analysis. And so our position is our client is a beneficiary of this. Understanding your hypothetical is that, let's assume she's not. By definition, the definitional term of interested person includes the status of a beneficiary. If you look at the plain language of the trust agreement, let's assume that...
So kind of an all dogs are collies, but not all collies are dogs. Or no, not all dogs are collies. Sorry, I had it backwards.
I'm vaguely familiar with that reference, Your Honor, but I think I understand your point, which is if you look at the trust agreement itself, which was included as part of the petition, even if you take the position at face value that my opponents had taken, which is my client is not a current income beneficiary of the trust currently in existence.
She's not any form of beneficiary of the trust in existence.
Well, again, we would take the different position because Texas defines beneficiary to include both current income and future, vested or contingent. So in this context, my client has a current vested interest in the principal held by these marital trusts. That's where we disagree. Nobody's disputing the fact that Jane has the right to all income. My client will never get the income from that trust or any of those trusts currently.
And she actually won't get the principal from the trust either, though.
She will. The principal that is held inside that trust upon Jane's death
will go to another trust.
Correct. Will immediately be allocated to subtrust, which is a commonplace practice in modern trust.
I'm aware.
For maybe I can clarify a little bit what I think Judge Morse is getting at. For purposes of the waiver question, are you saying that your argument, that the contours of your argument are the same? You have no different argument or additional argument in terms of interested person. Your argument is your argument, and it goes both to beneficiary and to interested person? Or is there any additional element to your argument that, okay, well, let's assume for the purposes of this discussion, she's not a beneficiary. Here's additional argument as to why she would be an interested person. Can you clarify that?
Absolutely, and a good question. I think I need to unpack that briefly, though, because on the one hand, I would say absolutely that is our position. It was the position we filed in our post-judgment briefing as well. The issue here is twofold, though. One, it is my client, by definition, because she's a beneficiary, is also an interested person. However, the court made the determination in its ruling on the motion for summary judgment without opining at all as to her status as an interested person. That's part of the issue and why we're here today, is because the court provided no basis or explanation as to why it had made a determination as to her status as an interested person without anything further. Our argument is, if the court is inclined, with respect to the beneficiary question, to rule she's not a beneficiary, that's well within the court's purview based on the pleadings and the motions filed. However, with respect to the interested person argument, as I quoted earlier, the statute expressly identifies that it's a facts and circumstances analysis. Beyond what the court ruled, it provided no basis as to why it determined that my client was not an interested person. That's the issue. For me as a practitioner, it's unclear to me, even if the court adopts your hypothetical, Your Honor, that she is not a beneficiary of those current trusts, she is named in the trust agreement as a remainder beneficiary of sizable assets that are currently owned by these marital trusts.
Right. I guess I was trying to focus this a little bit on Judge Morse's question, which is as to waiver. And so what I'm trying to get at is, did you make any arguments below beyond the beneficiary argument? I understand that you did reference the interested person in a footnote and then subsequently in the reply. But is your position that that was enough because the argument is the same? Or did you also argue interested person as a separate fallback position?
Understood, Your Honor. And I think the answer is yes, although I would also include the oral argument on that subject. That discussion also occurred at the oral argument on the motion for summary judgment, in which we reiterated the point that our position is, but because of her status as a beneficiary, she is necessarily an interested person.
You've got a minute left before your reserved time.
Thank you,
Talk
Your Honor.
about personal jurisdiction, Because that seems to be a tough issue for you as well.
Fair enough, Your Honor. And I think it's something initially that was addressed by Commissioner, now Judge Vandenberg. Principal place of administration is an issue that this court has seen before, Hogue v. French, other cases that have come out in the past decade. Here, the situation was one in which my client, as a remainder beneficiary, had no reason to believe that the trustee had any other residence or location other than Arizona. All of the trust administration, all of the documents that were provided, even if they were
But is
insufficient.
the jurisdiction question a matter of what your client believed or a matter of what is?
Well, it is.
Matter?
No, it's both, Your Honor. I
Okay.
think so. The basis initially to get into where we started was based on what she understood. Subsequent to that, the information that was provided simply verified that basis, which is that the trustee's only administration of the trust that could be produced at the trial level was through her counsel of record and through her accountant.
So administration, what do you mean? That's nominalization. What makes up the administration?
That's a good question, Your Honor, because it's a little bit difficult when you're dealing with an individual trustee. Here, the understanding generally of what an administration would be is producing accountings, making distributions from the trustee to the
So
beneficiary.
producing accountings, that was done in Arizona.
It came through her counsel to my client,
But
correct?
aren't the records and books actually in Texas?
That's what the trustee has represented, but there's nothing other than her declaration to support that.
Do
notion.
we
about
have,
the
is there
re-
any contrary?
Well, the only contrary is that everything that's provided, including both the correspondence from the trustee's counsel and the accountant, both who provided declarations, suggests that everything ran through them.
What about
They
the res?
produced I'm sorry?
What about the res, the property,
The actual property, as far as we're aware, of course, we don't have a full and complete record. As far as we're aware, is generally liquid. Brokers International is the primary asset, which is a business that runs throughout the nation, including in Arizona, has an ACC filing. Those assets are not particularly situs in any one location. So it's
not-
difficult to
it's
tie
not dirt.
a piece of real property. That would make it a lot simpler. Your Honor, I'm going to reserve the rest of my time unless you have any further questions for me.
No.
All right, thank you.
Thank you. Okay, Mr. Hesketh.
Good morning, Your Honors. My name is Matt Hesketh. With me is Sean Moore. We're from the law firm Sherman and Howard. We're here on behalf of Trustee Jane Mccarty. I'd like to start by going over why Michelle, and I'm going to refer to the parties by their first names just because I think it's easier. I mean no disrespect by that. of
Can
course.
I, counsel, just get one thing settled? Do you concede that, I guess, you would lose if the other party here, Michelle, was either a beneficiary or an interested person?
No, Your Honor, for a few reasons. First of all, under the Texas statute that would allow a court to order an accounting, under its property code 113.151, under subsection A, that deals with a beneficiary. That section allows a court to permissively order an accounting, but that requires that the petitioner actually show a basis for requesting accounting, for giving the trial court a justification for exercising the discretion to provide an accounting. So it's not mandatory that a beneficiary automatically gets an accounting simply by establishing that that person is a beneficiary. There's an additional showing required.
So let's assume that, and I understand you're saying the showing wasn't made, but let's assume it was made. Do you lose if Michelle is either, disjunctive, a beneficiary or an interested person?
No, Your Honor, because the trust document restricts the types of people who can request an accounting or the circumstances in which an accounting could be requested. Texas law also restricts when there's a trust declaration that provides a restriction on accountings. Texas law respects that, but sets out some further exceptions. And so not just any beneficiary is entitled to request an accounting in these circumstances. Also,
Right, and I guess I'm trying to also, you keep saying beneficiary, but I want to account for this other, thing, the interested party. So, I mean, if you could sort of weave that in as well.
right, and it's similar to the beneficiary, showing that would be required under 151A. Under 151B, it's also permissive. It's also discretionary. So an interested person would still need to show some reason for requesting an accounting in order to justify having the trial court exercise discretion in providing or ordering an accounting. Under the trust document, it specifically says upon a showing of good cause. And that's the fundamental problem. Even if Michelle
But the trial court didn't make a finding on that regard.
because there was
Trial
no
court found that she wasn't a beneficiary, so therefore not going to order an accounting. She's not entitled to one, not whether or not she'd made a sufficient finding.
I think the trial court found that she was not a beneficiary, but further granted the cross motion for summary judgment that she was not entitled to an accounting, which I think necessarily included the finding that she hadn't met the standard for requesting an accounting as either a beneficiary or as an interested person. Under the trust document, she would have to show good cause. She made no showing whatsoever. So even if she hadn't waived the argument that she's an interested person, which she did, she made no showing whatsoever as to good cause. And therefore, she failed to meet the standard, which is the reason why the trial court granted the cross motion for summary judgment that she hasn't satisfied the standard for demanding an accounting. As to why she's not a beneficiary, I don't want to belabor this too much. Your honors are aware of the point. She is not entitled to receive a distribution out of these trusts, and that substantially or substantively distinguishes her from all of the cases that were cited in the briefing. In all of those cases, you have someone who could potentially or will eventually receive a distribution directly out of this trust. The trust
And that's the distinction between a beneficiary, right?
Right.
Okay, so what about an interested person?
I think Michelle could have potentially been an interested person if she had made the showing. And as counsel mentioned while he was here, the definition, the Texas definition of an interested person is tied to the specific facts and circumstances of each case. It requires a case-by-case analysis. And that analysis is informed by the purpose for which somebody is contending that they are an interested person. In this case, Michelle would have to explain why she has an interest in the property.
You don't dispute that she's got a interest in the whatever res is left of this trust upon the death of the current beneficiary.
I don't mean to quibble too much, but there is a distinction that needs to be made. Michelle is not a beneficiary of the exempt family trust.
I didn't say beneficiary. I said she has an interest in whatever res is remaining because
Well,
she's going to be the beneficiary of a trust that is formed with that res.
Well, I apologize, Your Honor. I'm trying to get to that. So there are two family trusts at issue that will eventually receive the money. There's the exempt family trust and the non-exempt family trust. As to the exempt family trust, she is not a beneficiary. Those funds will go to Roger Mccarty's grandchildren and great-grandchildren, not Michelle. She has lumped this all together and said, I'm entitled to an accounting for everything, but she's actually not. She will never receive a
Is she
distribution.
the beneficiary of a future trust?
She is a beneficiary of
And what will go in to create that trust?
the property that is in some of the existing marital trust will
Okay.
eventually fund those trusts.
So I think that's what Judge Morse was getting at. She has an interest, at least in that line, that property.
And I heard you earlier, essentially, and I don't want to put words in your mouth, so correct me if I'm wrong. You said, it sounded like you said, I concede or I acknowledge that she has an interest. She could have been an interested party if she'd made the requisite showing of a need for a accounting.
She could have been if she had made that showing.
Okay, so you're not really disputing whether she has some interest in these trust assets. What you're disputing is whether she made the requisite showing to entitle herself to an accounting.
Correct. And
Okay.
she did not do that in this case.
Am I missing, I only see the good cause argument in a footnote in your answering brief, footnotes 5 and 6. Is there somewhere else where you sort of take it head on and say that's the crux of the case?
I can't provide you with a specific reference, Your Honor. I think it was addressed both in the briefing below, and if we only mentioned it in a footnote, then perhaps we should have made it a bigger point, but it is a big
They're
point.
relying on a footnote in the proceedings below, so I wouldn't hold you I wouldn't hold that against you too much.
The point is really twofold, Your Honor, though. She never made a showing as to why she would be an interested person in these particular circumstances, and specifically in connection with her request for an accounting. It's the purpose for the request that is determinative upon the facts and circumstances for why somebody would be an interested person. She set no analysis.
In this case, we have a situation where the trustee and the beneficiary are the same individual. So I guess, in talking about Jane, what is Michelle's eventual recourse if she doesn't have the ability to get this accounting? When you have somebody who could, at least hypothetically or theoretically, be engaged in some sort of self-dealing or improper distributions. Jane is in charge of checking herself in this situation. So what is the option? What is the recourse that someone in Michelle's or the grandchildren's shoes, I guess, has?
A couple of things, Your Honor. Part of the reason why it operates that way is because that's how Roger Mccarty set up his trust, and he specifically limited the circumstances in which an accounting could be provided. We're not taking the position that Michelle could never be an interested person or any of the other potential distributees out of the eventual family trust. We're not taking the position that under no circumstance could they ever be an interested person. We're taking the position that Michelle did not establish those facts, did not make a factual showing as to why that would be in this particular situation. So it's not that.
Can you tell me what those facts are that would have assuaged, that would have met your view of good cause? Give me some examples. What are good cause?
So Michelle has been provided with an accounting, actually. She's been provided with the tax returns and balance sheets that have detailed financial information, and they're in the record. They show the assets of the trust, they show the principal, they show distributions broken down by income and principal distributions, they show beginning balances for each year, they show ending balances for each year.
Okay, but I think you're sort of going past the threshold question of whether documents have to be provided in the first instance, which you say requires good cause and accounting. Right? So you sort of moved on and said, well, we provided these documents, and I guess you're going to go to where there's no good cause that she requires anymore, but good cause goes to the threshold issue, as I understand it, of applying to the court for an accounting. So my question to you is, what is that? What is good cause?
In this particular circumstance, it would consist at a minimum of why what she's been provided either isn't sufficient or substantiates actual particularized concerns. All that she has brought up are hypotheticals.
So you're not saying it's a threshold question?
No, I think
what she's been provided is well beyond the threshold of whether she gets to get anything at all.
I disagree, Your Honor, because in this circumstance, she actually has been provided with information. So if she's requesting some additional information, I think the facts and circumstances, which is what you have to take into account when determining whether the threshold issue of somebody is an interested person, in these circumstances, she has already been provided with a substantial amount of information. So
your position isn't that she's not entitled to an accounting, it's that she's gotten enough of an accounting.
No, it's that she has not made a requisite showing for requesting a court-ordered accounting as an interested person.
So the argument would be basically that because she's gotten either all or the majority of what she would be entitled to in her accounting, she hasn't met the good cause standard to request one.
Correct. And the statutory definition of an interested person is tied to the purpose for which somebody is requesting or is petitioning to the court, is holding themselves out as an interested person. In this instance, it's Michelle is requesting a court-ordered accounting. That's the purpose. And so in order to establish that she's an interested person, she would have to tie that to her purpose. And we submit that that purpose would require her to show why what she has received isn't sufficient or has given her some concern.
So good cause in that argument goes to the universe of documents provided. So we're providing an accounting, but good cause, as it's written here, is required if you want more than we've provided. Is that what you're saying?
Yes, Your Honor. In these circumstances, yes.
What if the answer is, I'm just concerned that there are games being played with my money? or that I'll eventually get? I mean, is that, and I just want to see the documents. I heard a rumor that the trustee was using the money to travel the world. Are those good cause?
If there had been no documents provided and there was some evidentiary support for a concern that would justify seeking an accounting on that basis, potentially, but those aren't our facts here.
And wouldn't you argue too that if a just bare allegation without any support, that would be sufficient? That would negate the good cause requirement altogether, because you could just assert, I'm concerned about money, and that would be sufficient.
Correct. And in this case, we don't even have an allegation that she was an interested person. As you mentioned, it was brought up in a footnote with no analysis, explanation, reasoning whatsoever.
What's the purpose, and I understand you didn't draft this document or you weren't in the Texas legislature, of a good cause requirement? What purpose does that serve?
Well, I think it serves the purpose that is mentioned in the trust declaration in order to save time, unnecessary costs and expenses, and to avoid the publicity which a judicial settlement might entail. I mean, that's the purpose. You want to avoid protracted family fights, especially when you have a situation, and there was the assertion that Jane is just blatantly violating her fiduciary duties. There's no evidence of that whatsoever in the record. Those are just statements of counsel. There's no evidence that Jane has taken any action that would violate her fiduciary duties. She takes those fiduciary duties very seriously, and she has acted as a trustee responsibly. As part of her fiduciary duties and her desire to responsibly administer these trusts, she has voluntarily provided this information to Michelle.
Although she didn't need to, though.
Correct.
Your client.
Correct. She didn't need to. Now, the trust declaration specifically says a trustee may desire, for whatever reason, to provide an accounting on a voluntary basis. It says it in the trust document. That's what Jane has been doing in order to avoid these family fights, in order to hopefully avoid unnecessary costs and expenses and to save time. Unfortunately, that didn't occur in this case.
If it's okay, I'd like to talk a little bit about personal jurisdiction. Is it accurate to say that all trust accountings, to the extent that we treat the documents provided to Michelle as accountings, that all trust accountings were performed in the state of Arizona and provided through an Arizona attorney to Michelle?
There's no evidence that the documents were prepared in Arizona. There's no evidence. They were transmitted to Michelle through an Arizona attorney, but that's all.
But the accountant is also an Arizona accountant, isn't he? She?
I don't think that there's any evidence in the record to indicate that one way or the other. I personally don't know the answer. I think there are assertions of counsel in briefing that might be the case, but I haven't seen any actual evidence that the accountant is an Arizona accountant.
Okay. Well, let's assume, because that was my understanding, let's assume that the accountant who prepared the tax documents that were provided to Michelle and the attorney are both in Arizona. Is that sufficient under Arizona's constitutional jurisdiction?
No, and it wouldn't be either for establishing the principal place of administration or the generally applicable standards for administering jurisdiction, either general or specific. You have the hiring of professionals in Arizona, and that's all. Jane has testified or has declared that the books and records of the trusts are all in Texas. None of the property is in Arizona. She does not administer the trusts in Arizona. The trusts have never had their principal place of administration in Arizona. None of that is contradicted by admissible evidence. None of it.
So the subject of this claim has to do with these accountings, whether there's an accounting warranted and whether it was sufficient. What was provided, the documents that were provided were sufficient. If the only evidence we have is as to that narrow portion of this trust and the administration of the trust is that is tied to Arizona.
It's not
I guess how is that not enough? Maybe not under the specific jurisdiction, but under Arizona's fairly broad constitutional personal jurisdiction.
Correct me if I'm wrong, Your Honor, but I think you're asking, does Michelle's claim or petition arise out of Jane's contacts with Arizona?
Yes.
And no, No, because Jane hasn't purposefully availed herself, hasn't purposefully directed activities that are necessarily tied to Arizona.
Except
She's-
for hiring an Arizona attorney and possibly an Arizona accountant.
Correct, but that's all. She didn't, those activities aren't inherently tied to Arizona. She just happened to choose professionals who are in Arizona. But the trust documents, nothing else about this situation inherently requires any contact with Arizona.
Wasn't there a tax return that provided an Arizona address for the trust?
It provided an address for the trust in Arizona, yes.
Okay.
But there's no dispute that Jane has a house in Arizona. She's a part-time visitor. She visits in the winter. And there's that house. That house was used on the tax form, which she filled out at a time when she was visiting Arizona. But that's all. And that's the sum total of the evidence for establishing personal jurisdiction over Jane. The house, the employment of professionals. That's it. Those contacts are ad hoc and sporadic at best. They are not continuous. They are not systematic. They're not pervasive. One other point, just to bring up, Your Honor, we made the argument in, Your Honors, we made the argument in our response, or answering brief, that the court could alternatively affirm on the basis that what Michelle has been provided is actually an accounting. I just want to bring up that Michelle actually admitted, so that there aren't contested issues of fact here, Michelle actually admitted in her response to Jane's statement of facts in paragraphs 32 and 36 through 39, that those documents actually do contain the information that would line up with the statutory definition of an accounting. So it's not like you would need to find facts in order to affirm on that basis, and you can, of course, affirm on any
Didn't
basis.
she also claim that, though, that those statements you provided didn't provide all the actual disbursements?
There's no evidence, though. The accounting simply needs to contain the information about assets,
But wouldn't an
disbursements.
accounting have some kind of verification this is true and accurate and complete, and she's alleging it's not complete?
There's no auditing, there's no verification, we're not required to provide backup. It's simply, these are the numbers. It's just providing information.
Seems like an accounting, though, by definition says, this is a complete and accurate, full statement of everything that we have.
Well, we are making that representation because they're tax documents. So we've made that representation to the federal government, and we're continuing to make that representation as to Michelle. But statutorily, there is no further requirement that they're verified, audited, that backup is provided. I see that I'm out of time. Thank you.
Thank you, counsel.
Your Honors, I'd just like to address a couple of points. First, with respect to Judge Perkins, I wanted to add a couple of additional interested persons that I think might be helpful. Trust protectors, investment advisors, those would all be individuals who might have standing as an interested person who are not beneficiaries.
I hate to monopolize your time on rebuttal, but can you list out for me, and I'm going to write, you can talk as fast as you want, all of the contacts that would provide our courts, Arizona courts, with personal jurisdiction here?
Sure. I think some of them have already been covered, but I think counsel misspoke when he said that that's the sum total. One of the ones that I think that Commissioner Vandenberg relied on heavily was the fact that not only did Ms. Mccarty have a residence here in Arizona, but that also she conducted business here in Arizona. That was provided in two different places. One, she specifically created an Arizona LLC, which she then subsequently asserted that she was no longer a member
But was that as trustee?
Well, Your Honor, I think that's where it gets into the gray area. Because you have an individual who is serving as trustee, and the line gets absolutely blurred. If her residence is in a particular jurisdiction,
Well,
and
it's
she
purely
creates...
representative, isn't it?
Pardon?
The office of trustee is purely representative.
It is, Your Honor, but when you have a situation where the beneficiary and the trustee are the same person, that line becomes blurred. That's part of the reason we're here today. When a trustee is acting in their normal capacity, but they decide arbitrarily to put on the fiduciary hat and conduct business a certain way, but also conduct business as a beneficiary a different way in the same jurisdiction, how does the court decipher which of those two is trustee related?
Well, wouldn't the answer be you're dealing with the goods of the trust?
Well, I think you could, but again, in this case, as Judge Perkins pointed out, the only circumstance or knowledge we have about the quote-unquote goods of the trust is that they are liquid, non-situs, and that the documents that are produced to a remainder beneficiary come solely through an Arizona attorney. And I just want to clarify your point, Your Honor. It is an Arizona accountant. He has a declaration. His name is Anthony Pescatore. He's an Arizona CPA.
Okay, so let's go on. So residence, business.
Sure, Your Honor. So
Okay.
she created a qualified personal residence trust, which owns the membership interest in that LLC. That is her personal residence. The same address she lists on the Form 706 tax return, it's the same address she lists when she created the LLC. It is her personal residence, despite the suggestion that she is a winter visitor. That's one basis. The other basis we asserted as well is she claimed in her declaration at the time of the dispute on the jurisdiction that she was a Texas resident because she voted there. She didn't obtain a voter registration card until almost 2 years after Mr. Mccarty died. She'd already been acting as trustee for over a year and a half.
Voter registration card.
Correct.
All right, so we have an affidavit from your colleague's client, Jane, and was that contested? Like, did you offer evidence to rebut those?
Your Honor, my client did submit a declaration to the extent that she had personal knowledge. Obviously, my client has no knowledge as to whether or not Ms. Mccarty transferred her voter registration beyond what was provided to her. However,
Right,
did
well,
provide...
it doesn't have to be just your client. It could be an investigator that says, you know what, I watched her in the entire, was there any evidence to rebut the contents of that affidavit?
Well, again, Your Honor, I think my client's declaration stands for itself. At that point, we were so early in the case, it didn't seem prudent or even, it was so early that the distinction of jurisdiction seemed premature. And ultimately, the court concluded because she ultimately heard the pleadings, she heard oral argument on that basis, provided both sides ample opportunity to provide that basis.
Let me
She
ask
then
you one
came
more
to that
question.
conclusion.
I know you're out of town.
Sure.
What if the trust hired a Florida accountant? Just because they met him at a conference a couple of years ago and pick up the phone and there's a Florida accountant who takes the role of the Arizona accountant here. Would that provide personal jurisdiction in Florida?
No, Your Honor, and I think in a vacuum, one professional representing a trustee is probably not sufficient for that state to exercise jurisdiction. However, as we presented in our briefing, this is pervasive. You have one accountant who prepares the documents, sends them to the lawyer, who then sends correspondence to our client as remainder beneficiary. And I want to make this point very clear because I think it's directly responsive to your question. In the petition we filed, Exhibit D is a letter from Mr. Rethor, who is co-counsel on this appellate brief and also the trust attorney. In that document, he expressly identifies that our client, Michelle, is a beneficiary and that accountings have been provided, although we dispute the sufficiency, and that they will continue to be provided. And yet, as we get to the petition, Jane then takes the position she's not subject to jurisdiction, that she doesn't have to provide an accounting to my client. At some point, that basis needs to be stopped. I think I'm finished, Your Honor.
I appreciate it. Thank you both very much, counsel, for your helpful arguments. We'll take it under advisement.
Your Honor.